Hello everyone, and thanks in advance for your time and attention. We are Group 5, and during this presentation, we are going to analyze the trial of the Chicago 7, which has been for several years the subject of legal problems as well as social clamor. The Chicago 7 trial turned into a turning point in public debates about the Vietnam War, student demonstrations, and the decency of the federal judicial procedure. China had gotten communist in 1949, and communists controlled North Vietnam. The United States was worried that the communists would spread from South Vietnam to the remainder of Asia. In the Gulf of Tonkin, the North Vietnamese dispatched an attack on the US Navy. This occurrence gave the United States the support it expected to increase the war, and accordingly, the Vietnam War happened. This event was even shown as a movie directed by Aaron Sorkin as The Trial of the Chicago 7 in 2020. The film follows the Chicago 7, a gathering of anti-Vietnam war demonstrators associated with scamming to prompt protesters at the 1968 Democratic National Convention in Chicago by intersection state lines. The Chicago 7 were 7 defendants charged by the United States federal government with conspiracy, crossing state lanes with intent to incite a riot, and other charges related to the anti-Vietnam War and countercultural demonstrations in Chicago. The group was formed by influential American activists who were well integrated into the political world. On the one hand, we find Tom Hayden and Rennie Davis, who were the two leaders of Students for a Democratic Society, while on the other end, there were Abby Hoffman and Jerry Rubin, which were the two main phases of the hippie movement, also known as the Youth International Party. Then the group was also formed by David Dellinger, who represented one of the most famous faces among American pacifists, as well as John Froines and Lee Weiner, who were the only two defendants to be acquitted by the jury on both of the counts charged against them. Nonetheless, the last man, Bobby Seale, who was the founder of the Black Power political organization known as Black Panther Party, was forbidden from the trial and thus made it 7 instead of 8 people. Thus, the genuine story of the trial of the Chicago 7 shows that they ventured out to Chicago to fight American involvement in the Vietnam War, and the fact that Democratic official competitors, Hubert Humphrey, didn't censor the war. By the year 1968, 15,000 protesters went to the convention at Green Park. News cameras got the fights on camera and how a few captures were made, including the death of the Chicago 7. The scene was subsequently called a police revolt by the US National Commission on the Causes and the Prevention of Violence. The United States federal government met on September of the 1968 to consider 4 main criminal charges against 8 protesters, which were the following: an interstate conspiracy by protesters to cross state lines to promote a riot and civil disorder in violation of federal law, violations by police of the civil rights of demonstrators by use of excessive force, TV network violations of the Federal Communications Act, and TV network violations on federal wiretap laws. In addition, while the jury ruled on the verdict, Judge Hoffman cited all the defendants as well as their lawyers for numerous outrages at the court, imposing sentences ranging from 2 months to 4 years. The accusations of contempt were presented again before a different judge who did not sentence any of them to prison or payment of fine. And finally, now that you have a more definite view of what happened, during this presentation, we are going to deeply analyze some crucial topics which have raised some controversial social issues like Rap Brown Law and conspiracy charge, the controversial case of Bobby Seale, and how the civil rights of demonstrators have been violated by use of excessive power. And now I would like to hand it off to my colleague Gauthier.
The whole trial of the Chicago 7 was based on different charges, but the main charge that was retained against the 7 activists was the interstate conspiracy by protesters to cross state lines to promote riots and civil disorder in violation of federal law. During the trial, the 7 activists tried to protect their freedom of speech and the real fight behind all of this. But the US court did not support this evidence, and they rely on the wraparound law from the Civil Rights Act of 1968. So what is the wraparound law? The wraparound law came out of the Civil Rights Act of 1968. It is also known as the Anti-Riot Act, Title X, which makes it a federal crime to use interstate or foreign commerce routes or facilitates to incite a riot. The Anti-Riot Act got its name wraparound law for the arrest and trial of H. Rap Brown, an Afro-American civil rights activist in 1967 for carrying a gun across the state lines. The wraparound law is legally binding on all of US citizens, but it has been criticized from the start since it was implemented to apparently stop riots at its source. However, its vague language has always been at odds with the right to freedom of speech. For a long time, awareness of the act was low since it was not enforced as such in the aftermath of the civil rights movement. In the case of the Chicago 7, Judge Julius Hoffman shows a significant prejudice of the prosecution according to 2 events. So in the first place, the judge come back on the events of the night of the riots. Davis tried to pacify officers trying to arrest a minor who was climbing a flagpole. After the police clubbed David's head, an enraged Hayden exclaimed, "If blood is going to flow, then let it flow all over the city." The defendants were eventually cornered by police, who removed their badges and proceeded to assault them. Abby deduces that Hayden had misspoken, claiming that the original statement would have stated, "If our blood is going to flow," and Hayden asks him to testify. The second events come from an undercover officer that gives a false narrative of the initial protest. Abby and others led a protest to the police station where Hayden was being kept, but turned around upon seeing the police blockade outside. When trying to return to the park, police had taken control of the hill with orders to disperse the crowd. A riot ensued and the protesters clashed with the police in attempt to claim the hill. Kunstler makes a point that none of the defendants instigated the riots. According to the US Criminal Court, these events were clear evidence that actions from the Chicago 7 were criminal actions legally enforceable by the wraparound law, although there has been clear evidence that the Chicago 7 were not necessarily the only one that started the riots. On February 18, 1970, each of the 7 defendants was acquitted of conspiracy. Freund and Weiner were acquitted completely, while the remaining 5 were convicted of crossing state lines with the intent to incite a riot. On February 20th, they were sentenced to 5 years in prison and fined $5,000 each. But 2 years later, on November 21st, 1972, all of the convictions were reversed by the United States Court of Appeals for the 7th Circuit, which deemed that Judge Hoffman had been biased in not permitting defense attorneys to screen prospective jurors for cultural and racial bias. The court also determined that the FBI had bugged the defense lawyers' offices. The Justice Department decided against retrying the case. So now I will hand it to my colleague Giovanni that will talk about the case of Bobby Seale.
Thank you, Gauthier. So, as said by my colleagues, the movie The Trial of the Chicago 7 features historical events and covers the judgment of some of the key political activists in the United States. Bobby Seale, known for his activism and known for the creation of the Black Panther Party from self-defense, was one of the key people featured in the movie. He was a suspect for his activism, including monitoring of the police brutality. The personality of Bobby Seale should be featured as he does not fall into the general paradigm of the 7 individuals charged and makes the case of the Chicago 8. The human rights-based focus on Bobby Seale was largely inspired by the teaching of Malcolm X. They selected the similar directions in the contribution to the teachings. Seale was allegedly charged for spreading conspiracies amidst the anti-Vietnam protests in the United States at the time when the 1968 Democratic National Convention took place. There were some clear human rights abuses against Seale as the case was being reviewed by the judge. The fundamental right to dignity was abused as Seale was walking to the room bound. Besides that, he did not have the chance to invite the lawyer to the courtroom. The lawyer who was assigned by the institution to Bobby Seale was not the perfect character to undertake the role and see it forward. As the court was reviewing his case, Seale was outraged and he could not have an appropriate legal protection. For that reason, he started to yell, "I object," every time the judge was about to mention his name. The biggest issue in the process of his case review lied in the inability to receive an appropriate protection of the constitutional rights, and he suspected that the judge acted against his based on the racial motive. Unlike the other individuals charged in the Chicago 7, Bobby Seale endured more severe charges. He did not live in the appropriate living condition at that moment too. Specifically, he was handcuffed with his leg being cuffed to the chair, and at some point he was also found in contempt. In fact, Bobby Seale recognizes that his position could be a lot different from those facing charges in the trial. For that reason, he acknowledged that one could be acknowledged as an enemy of the state and assumed that he could be put in prison. Besides, the other distinctive feature that proves that Bobby Seale was forcefully charged lies in the way that vague evidence of the case. In essence, the evidence was slim with little to no sign of planning the attack during the Democratic Convention. Seale also claimed to not be familiar with the other individuals charged in the case. Specifically, Seale spent only 2 days in Chicago during the convention, and there was no chance that he could be planning the attack with others. Eventually, Seale faced charges to 4 years of imprisonment without carefully reviewing the evidence in the case. It was likely that the outbursts of Seale during the court trial negatively affected the flow of the case. Besides that, there is a vision that the attitude of Seale in the court trial also convolved the judgment against the other 7 individuals suspected for the case. And in 1972, Bobby Seale was released from prison and the charges were eventually dropped. Besides the infamous Chicago 8 trial, Bobby Seale was also charged with attempted murder of one of the members of the political party he represented. During his absence in prison, his wife likely had an affair with a member of the political party, which is why his personality remains controversial these days. In addition to that, it's important to note that Bobby Seale was charged amidst the era when racial crime were on the rise. Many individuals like him could be put in prison merely based on the skin color. The insinuation for alleged organization of riots against the police during the Democratic Party convention was used as an argument to intensify the societal polarization and general acceptance of the racial issues. The time he spent in the court and the attitude he witnesses with his personality reminded of the absence of genuine justice in the US judicial system at that time. Bobby Seale had no legal chances for protecting his dignity, which is why he was yelling "object" to the judge of any charges he faced. The case amplified that a different treatment and approach was used towards the individuals of white origin as well as toward the individuals of color. The judge was clearly biased and did not respect the basic right that a person could be entitled in the case of Bobby Seale. For that reason, the legality of the imposed charges is being questioned. My recommendation on this topic is to remember about impartiality of the judiciary and ensure that a fair judgment would be made in the cases of trials similar to that of Bobby Seale. Hence, I think it's very important for every person, regardless of their origin, to have a voice in the court as well as to be sure that the court would undertake a fair judgment. In the late 1960s, the situation was somewhat different and there were a lot of elements in the puzzle that were not respected. Hence, it's a reminder for all of us to respect human rights in any circumstances. And now I'll hand it off to my colleague, Alexander.
Thank you, Giovanni. So after the Second World War ended in 1946, the United Nations came up with 24 several universal human rights, which every human should possess regardless of their ethnicity, religion, colors, skin, and further on. When looking at the trial of the Chicago 7, we can see that several human rights have been violated. One of those was the violation of the human rights article number 6, which is the right of a fair trial. In the very beginning of the movie, it was easy to identify that Judge Hoffman is neither independent nor impartial, an impartial decision maker, and was eager to put the accused ones behind jail fast. Therefore, he was hiding crucial evidence, has taken testimonies of witnesses which were manipulated, and was creating a jury which was in favor of his ideas. Furthermore, we could also see that the human rights article number 7 was violated, which is no punishment without law. An example of this was while one of the protests happened, the main characters were able to flee into downtown where a group of policemen found them. Instead of arresting them, they were putting down the badges and name signs and started beating them up, also throwing them through the windows of a restaurant. Yet, the protesters gave them no reason to do so and were peacefully assembling. Now, I will give a small film insight on what I mean with manipulated testimonies.
See what I'm seeing. Hey! Stay back there, all of you! Police, stay back.
Listen, everybody stay cool.
Shut up. Tell him to get back. Tell him to get back.
Did he tell the crowd to back down? Everybody get back. I'm all right. Stay cool.
He was egging them on.
Did you?
So there you see one of those examples. Continuing, there's also the case of voidure. It is a legal phrase for a variety of procedures connected with the jury trials. It originally referred to an oath taken by jurors to tell the truth. An example of the truth told is when Mr. Clark gave his testimony. Before retirement, he was the general US attorney and started investigating into the demonstration. They came to the conclusion that the police were the initiator of the violence and that the accused ones had nothing to do with it. Yet, his testimony was heard in an empty courtroom, and Judge Hoffman decided that the testimony of Mr. Clark is not relevant for the trial and that he will not be heard by public. Furthermore, there is also Justitia. You can see her in the picture on the left. She's holding scales in one hand, which measures the strength of a case's support and opposition. Also, she's blindfolded, which represents impartially the ideal that justice should be applied without regards to wealth, power, or other status. It nearly stands in all courtrooms around the world and presents the justice and functional system. In the Chicago 7 trial, Judge Hoffman completely ignored these principles and was prejudiced even before the trial started. Now I'm handing over to Gauthier.
So now to conclude, I'll talk about the current events. So for a long time, awareness of the act was low since it was not enforced as such in the aftermath of the civil rights movement. However, during the protests in 2020 against racial injustice and police brutality, the act has made the headlines again. Its first prominent use in recent years was in the aftermath of the Charlottesville Unite the Rights rally in 2017. The Anti-Riot Act has been used against many members of the Rise Above movement who participated in and organized the rally, including people who did not attend the rally in Charlottesville. So more recently, Attorney General William Barr cited the 1968 Anti-Riot Act when speaking of those who were protesting in the wake of George Floyd's death in May 2020. It is a federal crime to cross state line or to use interstate facilities to incite or participate in violent rioting, Barr was reported. Thank you for listening, and we hope you enjoyed our presentation.